Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the second part of the Queen and Barnes. Now, if you haven't watched the first video, I recommend doing that now. I will link it above. And basically, as a recap, if you decide not to watch it or if you've already watched it and maybe don't remember the details all that well, Mr. Barnes was charged with storage of a firearm contrary to the regulations, because they said that the metal containers he was using to store his firearms, including some automatic firearms, were not safes. Now, that argument was rejected by the court. The court said those are sufficient to count as safes, and so we acquit. But the Crown didn't stop there. They said even if he's acquitted, even if he's found not guilty of the storage offenses, we still want to take his guns. And the way they were seeking to do that was under the provisions of Section 117.05 of the Criminal Code. What that allows is where firearms have been seized, they can then apply for essentially an order that forfeits them to the Crown. So now the Crown owns them and can do what they want with it, which is always to destroy them. And also to issue an order prohibiting the person from having firearms going forward. So heavy stuff. Mr. Barnes, of course, was not down with that, so the second part of the case deals with their attempt to ban him from having guns and to take all the firearms away. So they note the evidence. Mr. Barnes is 76 years old. He's lived in the North York area for 43 years and at his present address for the past 10 years. The respondent has a colorful and gregarious personality. Mr. Barnes often goes by his childhood nickname, Johnny Sombrero. He's well known in his neighborhood and, in particular, in his very quiet apartment building. Now, I'll just note here, unfortunately, Mr. Barnes has passed on. It's kind of sad because this is a guy I've never met, but he's kind of a heroic figure. It's kind of badass what he was up to here. So, Mr. Barnes has experienced some health problems. He is a diabetic. 3 years ago, he underwent triple bypass surgery and was hospitalized for 27 days. Several months later, the respondent developed a staph infection that necessitated another hospital visit. In 2010, Mr. Barnes spent 6 days in the hospital for fluid in his lungs. The respondent has been a gun collector for about 50 years. He is a regular participant in gun shows, which sometimes involve overnight stays outside of the city. It was through Mr. Barnes' involvement in gun shows that he became acquainted with Richard Kornblum in 1978. Mr. Kornblum describes the respondent as a passionate collector of valuable historical weapons who enjoys sharing his knowledge with others. According to Mr. Kornblum, Mr. Barnes is scrupulous about firearm safety. The respondent is the leader of the Black Diamond Riders Motorcycle Club, BDR. He is the last of the group of 14 men who founded the club in 1950. Within the club, Mr. Barnes is affectionately known as the Supreme Commander, a reference to the position held by General Eisenhower during World War II. The respondent is proud of his involvement in the club. He wears clothing and jewelry bearing the club logo. He carries a business card with the club name and his nickname, Johnny Sombrero, on it, and his car has a sticker with the club logo on it. Apart from passing references to fights among motorcycle clubs in the 1950s, the only evidence put before me connecting the BDR to any form of violence was an incident in 1992 where members of the Satan's Choice shot Mr. Barnes in the face. At the time, the respondent and his companions were unarmed. And I think it's hard to put too much weight on him having been the victim of violence, especially in a situation where he was unarmed. But that's my editorializing here. On December 7th, 2009, Constables Gill and Weeks noticed a vehicle that failed to stop at a stop sign. They followed the car and stopped it at the rear of an apartment building. Mr. Barnes was the driver. The respondent was cooperative and friendly when dealing with the officers. Constable Gill exercised his discretion not to issue a certificate of offense and simply warned Mr. Barnes about the driving infraction. Both officers testified that the respondent described himself as the Supreme Commander of the BDR during conversation with them and showed them a business card with the name Johnny Sombrero. In addition, Constable Weeks stated that Mr. Barnes made a number of comments he considered unusual. The respondent mentioned that he had a number of guns upstairs in his residence. Mr. Barnes also said that BDR are wasps that fight for their country against all enemies, foreign and domestic, and that they had trained police services and the military in firearms use. The officer filed a field information report about the contact and flagged it for the attention of the Biker Enforcement Unit. Being talkative with the police did not help Mr. Barnes here, although it seems likely that he was just being chatty. During his testimony, Mr. Barnes denied telling the two officers that he was the supreme commander of the BDR. According to the respondent, the police have put this information on CPIC. The comments that Constable Weeks attributed to Mr. Barnes were not put to the respondent during cross-examination. Now, this is a bit of a big deal, and I'll explain why. There's a general rule that if you want to rely on something as part of sort of your version of events, you should put it to a witness when you're suggesting something about them, so that that witness has an opportunity to respond to it. Where that's not done, the court can make what's called an adverse inference to suggest that because you didn't put it to them, we're going to put less weight on that. So they really should have put these comments to Mr. Barnes so that he has a chance to respond to them, because otherwise it's not really fair. The court can sort of infer that maybe you didn't put those comments to him because you were worried that he might have a good explanation. So this is a rule of trial fairness, and so that's why the court is making this comment here. Although the warrant and the way in which it was executed were not challenged by way of a charter application, Mr. Costa alleged that the police mistreated his client during the time they were in his residence. This was advanced as an issue bearing on the assessment of credibility. It is common ground that the police contacted Mr. Barnes and, as a ruse to get him to open the door of his apartment, told him that someone was breaking into his vehicle. Although he was skeptical about the validity of this information, the respondent got dressed and opened the apartment door. As soon as the door was ajar, officers entered into the residence. It is at this point that the account of events significantly diverge. I don't really like this tactic, but I get why they might try this. They might have been concerned that he's a well-armed individual, and so they wanted to sort of lure him out. But still, it involves some deception, and police are allowed to deceive you. They may do so in all sorts of circumstances, but I still don't have to like it. I'm going to skip over a little bit here. Suffice to say that Mr. Barnes indicates that they use substantial sort of violence against him, and that the constables disagree with that. But I'm going to skip over this just for the interest of time. So, analysis. It is the Crown's position that forfeiture of the respondent's weapons should be granted due to the cumulative effect of three factors. So not saying, each of these on its own, they're saying all together. But let's look at these factors, because I suspect that you're going to have some opinions on them. I've got some opinions of my own. So factor number 1. Mr. Barnes is a senior citizen whose health has caused him to spend significant periods of time in hospital. In addition, he regularly travels to gun shows, which can lead to him being away from his home overnight. As the respondent lives alone, his weapons are unattended during these periods when intruders could gain access to his firearms. So they're worried he might be the victim of a criminal offense, and because of that, they want to take his guns away. And in particular, they're worried about his health. And they're saying because maybe you're not healthy enough to own guns is kind of reading between the lines here. Okay, next. Due to his longtime residence in his neighborhood and his position as the leader of the Black Diamond Riders, Mr. Barnes has gained some notoriety. The respondent's contact with the media during his trial has also made public his possession of a large number of firearms. This increases the likelihood that Mr. Barnes' gun collection will become a target for thieves. So because we brought this case, and because the media has heard about it and talked about your story, now we need to take your guns because we came and charged you with things. I have some problems with this. I have some real problems with this notion that because, his ownership of firearms has become public, particularly given that it was through the police's action here, now they need to take his guns on that basis. Okay, you guys can leave your thoughts on, the arguments here in the comments below, because I'd love to hear what you think of these. So the comments made by the respondent to Constable Weeks and Detective Ribito and his inaccurate recounting of the events involved in the execution of the warrant raised concerns about his attitude and perceptions. So I accept that there are always concerns about the vulnerability of a large gun collection, especially one involving automatic firearms in an urban environment when the owner is away from the residence. Indeed, during Mr. Costa's submissions, he commented that it might be prudent if the respondent supplemented his present security measures by installing an alarm system. Although this is a wise suggestion, I found that Mr. Barnes' firearms are stored in a manner that complies with the regulations and, as described in the evidence, he's taken some additional precautions to enhance their security. Detective Rubito testified that he was not aware of any issues involving the police in Mr. Barnes' building since the warrant was executed or in the 10 years preceding its execution. Mr. Barnes has been a gun collector for roughly 50 years without the loss or theft of his firearms or any other incidents involving his weapons. Further, in a quiet building where the respondent is well known, one might anticipate that the neighbors would notice strangers in the area of Mr. Barnes' apartment. In the event that Mr. Barnes becomes ill for a significant period of time, he also has the option of asking his friend, Richard Kornblum, to store his firearms, something that Mr. Kornblum testified he has done for others. With respect... Oh, and I'll just provide some background here. Mr. Kornblum, as is noted in the previously covered parts of this, has a firearms-related business, which puts him in a particularly good storage situation, especially when we're talking about prohibited automatic firearms, for which Mr. Barnes was grandfathered. With respect to the comments to the officers described Mr. Barnes making to them, I believe that they were said. Given Mr. Barnes' belief that the police had put information about him being the supreme commander of the BRD on CPIC, it seems plausible that he would describe himself in this fashion when speaking with Constables Weeks and Gill. I do not find it unusual that Mr. Barnes would mention his ownership of guns to Officer Weeks. It would be reasonable for him to believe this information was also on CPIC. I give little weight to the other unusual comments attributed to Mr. Barnes. Since they were not put to the respondent in cross-examination, he had no opportunity to respond to or provide an explanation for a factor that is being raised in support of the forfeiture order. See the case of the Queen and Giroux. The possibility that the utterance were misunderstood, misinterpreted, or were not intended to be taken seriously cannot be excluded. In any event, even if the unusual comments are taken at face value, I am not persuaded that they are sufficient to raise legitimate concerns that Mr. Barnes lacked the responsibility and discipline the law requires of gun owners. In relation to the events at Mr. Barnes' apartment when the warrant was executed, I am satisfied that the respondent was startled and frightened by the abrupt entry of the police into his home and that he fell backwards to the floor. I find that Mr. Press and Detective Rubito were mistaken about Mr. Barnes' position on the floor, a sign of human frailty in a swiftly moving situation. Just as a comment, people often get details wrong in these sort of fast-paced situations, and it's not because they're lying or intending to deceive, usually. It's often just because once your adrenaline is going and things are happening, people aren't as observant as they would like to hope that they are. And often your memory will fill in gaps of things you think probably happened, but maybe you didn't actually see or didn't actually remember. So these sorts of inconsistencies are not uncommon, and they don't necessarily indicate deception, although they might, but they may indicate frailties in memory. I do not believe Mr. Barnes' account of being mistreated by the police. My reasons for this conclusion are as follows. The respondent's insistence that Mr. Press was the first officer through the door is contradicted by the 3 police witnesses. More importantly, it is highly likely that a civilian employee of the police who is not permitted to carry a firearm would be the first to enter a residence with a public safety warrant involving numerous firearms was being executed. I'll skim over here a little bit because essentially they don't find that he was accurate, but I'll skip over things. The respondent's claim that he had a gun pointed at his head for hours is implausible. I don't know about that because I actually have seen a number of videos where people have had firearm raids and have had firearms pointed at their head for substantial periods of time. But regardless, the court found that this was all inaccurate. So they noted, I'm concerned about Mr. Barnes' inaccurate characterization of his interaction with the officers. However, this must be assessed in conjunction with all of the other evidence. Harry Barnes has been a licensed gun owner and collector for 50 years. He's known for his careful compliance with firearm safety. There's been no evidence of any violation of the firearm legislation. There's no suggestion of any psychiatric condition, mental disorder, or suicidal thinking. Significantly, Mr. Barnes' actual conduct in dealing with the police was described as polite and cooperative. Assessed in the context of the evidence as a whole, I find that the Crown has not shown on a balance of probabilities that it is not desirable in the interest of safety of Mr. Barnes or any other person that he should possess any firearm. Accordingly, the application is dismissed. So they didn't get to take his guns here. They didn't get to ban him from having guns. I have some concerns about the arguments they were making because, to my mind, like saying, because we came after your guns, it became known that you had guns, and so now you can't have guns anymore. That seems really unfair to me. It seems like playing dirty, and I don't like it. I can see why the Crown is making these arguments. They don't want, they're concerned about automatic firearms, and their notion is that nobody should have these things. I suspect, this is me hypothesizing here, but I suspect that they were thinking nobody should have these things. We're happier if they can get chopped up and destroyed. But here they were not successful. Mr. Barnes got to keep all of these items. As noted, he since passed on and kept these things up until his death, from my understanding. I've received some information from a source. I didn't check if it was okay for me to pass along the source's name or any details here, but this is kind of a happy ending. The reason why I say that is that I understand that upon his death, Mr. Barnes had made taken appropriate steps to ensure that his firearms would be passed on to people able to have them and places able to take them. And so accordingly, none of the firearms that the Crown and the police wanted here were forfeited to the Crown and police even after his death. So just from my perspective, that kind of makes me happy. I'm glad that he gets the last laugh on that one. So that's sort of concludes the story of Mr. Barnes. From reading this, I kind of wish I'd been able to meet the guy, because it just seems like he lived a larger than life sort of existence. It seems like he had a lot of fun right up until he's getting charged and having to deal with all this stuff. I really sort of appreciate his story, and I appreciate him sticking to things. And because he did, and because he ultimately prevailed, we have a case that is fantastic. Frankly, all gun owners kind of owe him a debt here, because this case is fantastic on storage issues for gun owners generally. So I'm glad to be able to share this story with you. Please like the video if you found it helpful. If you like the story of Mr. Barnes as well, please share it with your friends, and please subscribe to the channel for future updates. I want to give a thank you to $50 supporters George and D. Mo. A special thank you as well to $30 supporter Steve Browning, and a thank you to all of my $10 supporters who will be following in the crawl right after this. I will link again the case of the Queen and Barnes, as well as my previous video on Mr. Barnes and his case, as well as the Patreon below. Thank you, and I hope this has armed you with knowledge.